Okay.
Alex, you're muted. Okay.
Sorry. Okay, there we go. Unmuted now. Good to meet you. Good to meet you.
We can hear you now. Hi, how are you?
I'm good, thank you. How are you?
I'm fine, thank you. You're in Hong Kong or where?
Yes, in Hong Kong. Yeah.
Oh, okay. All right.
Yeah, exactly. So, hello, hi, Sharifa. Hello. Hi. Are you at the centre at the moment, David, or are you?
All right. Good evening, everyone. Welcome to today's edition of BicTok Expert Determination. New Kids on the Block. We have very interesting speakers with us today. My name is Sharifa, and I'll be introducing the moderator. The moderator today is Mr. Rodney Martin. Mr. Rodney is the Chief Executive of the Charlton Martin Group, with a career that includes roles as Group Regional Director and Senior Vice President at two prominent contracts consultancy firms in the Asia-Pacific region. With 38 years of experience, Rodney has dedicated 27 years to senior level roles within this region. Throughout his career, Rodney has cultivated a global perspective by working with diverse clientele across Europe, Africa, the Middle East, and India. His academic foundation includes dual qualifications in quantity surveying and law, complemented by his status as a chartered quantity surveyor. He specializes in construction contract consultancy, offering expertise in contract documentation, contractual claims management, dispute resolution, and dispute avoidance. Rodney's professional credentials extend to being a mediator, arbitrator, and adjudicator on the panel of the Asian International Arbitration Center. He's also a fellow of the Chartered Institute of Arbitrators, as well as the Malaysian and Singapore Institute of Arbitrators. His work includes appointments as an expert witness on matters related to quantum and delay, as well as his roles as an arbitrator, mediator, and adjudicator. Rodney has been a dispute adjudication board member in Malaysia. He has been based in Kuala Lumpur since 1997. Up next, we have Mr. Jeremy Glover. Mr. Jeremy is a partner at Fenwick Elliott LLP, the UK's largest construction law firm, and is listed as the leader in his field in Who's Who Legal. Mr. Jeremy is an accredited adjudicator, vice president of the Conflict Avoidance Coalition, and a member of the CARB Adjudication Subcommittee. He's also a FIDIC certified adjudicator, a member of the FIDIC President's List, and of the FIDIC Net Zero Task Group TG23. Jeremy is the co-author of Understanding the FIDIC Red and Yellow Book, a clause-by-clause commentary, the third edition of which was published in 2018, and lead editor of Building Contract Disputes, Practice and Precedents. He's a member of the Board of Examiners on the Construction Law Master's Program at King's College, and also teaches on the Master's Building Information Modeling Management Program at Middlesex University. Jeremy serves as the president of the DRBF Executive Board. Our second speaker of the day is Mr. Matthew Finn. He is a senior managing director at Ancora based in London, and he's regularly appointed as an expert witness in the field of quantum damages in energy, infrastructure, and construction matters. He has given oral expert evidence in many high-value international arbitrations up to $10 billion worth of disputes, and in litigation on many occasions under both traditional cross-examination and under concurrent evidence commonly known as hot tubbing. Matthew has submitted over 100 quantum expert reports in litigation and international arbitration under ICC, SIAC, UNCITRAL, LCIA, SCC, and PCA, as well as acted in matters in mediation and adjudication. He was recently appointed as an expert and testified on one of SIAC's largest arbitrations in its history, involving many complicated claims and issues. Matthew has been recognized in Who's Who Legal in Arbitration, Quantum and Delay, Energy and Construction expert chapters in publications in 2018 to 2024, and he is ranked as the global elite thought leader in expert construction, quantum, delay, and technical, and he was the sole winner of the arbitration expert witness at Lexology's Client Choice Awards 2021. He is also a RICS accredited expert witness, accredited and practicing member of the Academy of Experts and member of the Expert Witness Institute. And last but not least, we have Mr. Gananathan. Mr. Gananathan heads the practice of Gananathan Law, which is specialized in dispute resolution, dispute avoidance, and front-end advisory and drafting in construction, with emphasis in large infrastructure projects, both locally and internationally. He has experience spanning 32 years in the field and regularly appears as counsel in arbitrations, the High Court, and appellate courts. Apart from handling construction matters, he also appears as lead counsel in commercial and corporate litigation disputes. He is also a panel arbitrator and adjudicator with the AIAC and often sits in both capacities. He is also a past president of the Malaysian Society of Adjudicators. Now, before I pass the floor to Mr. Rodney Martin, I'd like to remind everyone to have their first and last names displayed on their names for CPD record purposes. And if you have any questions, please put them in the chat box, and at the end of the session, our panelists will address them. Now, over to you, Mr. Rodney.
Thank you very much indeed, Sharifa, for the introductions, and we're in very good company this afternoon. Ladies and gentlemen, we've got about an hour to go through these two new kids on the block and look at the elements and the characteristics of these ADR methodologies, which have recently become popular. To begin with, I'd just like to say a few words of introduction. Arbitration has long been an expensive and usually lengthy process of resolving disputes, which is unsatisfactory for the users. We in the dispute resolution industry must do better in serving the parties we represent to resolve their disputes. Recently, there's been much interest in mediation as a shortcut to dispute resolution, but the uptake, certainly in these parts, remains slow. Expert determination and early neutral intervention may also offer hope for speedier, cheaper dispute resolution. To be clear, expert determination is where, by agreement of the parties, a dispute is submitted to an expert who makes a determination on the matter. The determination is binding unless the parties agreed otherwise. Early neutral intervention is where the parties invite a neutral third party to give an opinion on the merits of their case or aspects of their case. It's clear from what I've read and understand in my own experience that early neutral intervention can be a lot more than just that, and we'll hear more from the panelists in a moment. Both forms of ADR are increasingly becoming recognized mechanisms for efficient dispute resolution, avoiding arbitration or litigation, and the time and cost that those involve. So we're going to hear from the panel on their experience on both methods, the pros and the cons, and what can work well and what perhaps goes wrong with these methods. So first of all, I'd like to hand over to Jeremy to start with, starting with expert determination. We'll deal with that first with the panel, and then we'll go on to E&I. Jeremy, what do you think?
Okay, thank you, Rod, and thank you very much for the kind invitation to be with you today. With expert determination, it's something that you see, this is from my UK-based experience, it's around quite a lot. As Rod has said, I mean, the idea is simple, that an independent third party will consider claims made by each side. They'll issue a decision, which Rod has said is usually, but not always, binding on the parties. And what you find and what people always say is the process is particularly appropriate for determining technical disputes. So, for example, valuation issues. And so this is said to be one of the key advantages, and I don't disagree, is that you choose your expert because of their expertise in the subject in question. You're not bound, when you set up a contract to who the expert will be. You can cut your cloth. You can tailor the choice of the expert. And the thing about expert determination, where I see it, is that it's usually a creature of the contract. There'll be a couple of clauses in the contract setting out brief details of the agreed expert determination process. And that can and often will set out those areas that an expert can actually make a determination on. It isn't the case that parties can do this. Parties don't generally tend to agree that the expert can hold forth on all the issues. There's normally a sort of limit on the type of issues that they can address. All that said about what you typically see, it turned out that my very first experience of expert determination was slightly different and much more closer to short form arbitration or even adjudication. The parties had agreed that there could be an expert to determine issues in dispute. They had agreed that the expert should be a barrister from a well-known set of chambers, and they'd set out a brief process, including submissions that could be made to the barrister. And then after the initial submissions, the barrister was in charge of the process. They could ask questions, and the idea was that a binding decision was reached within a short period, a much shorter period than you'd get if you'd gone to court or arbitration. So in many respects, although it was dressed up as an expert determination, it was more a short form dispute process, but it was a valuable one because the parties were able to resolve specific differences much more quickly and much more cheaply than they were under a sort of formal arbitration process. But it's more typical that you see an expert come on board and they're asked to deal, as I've said, like a valuation issue. Quite recently in the UK courts, there was a case where the expert had been asked to determine whether or not a project was practically complete, whether the project was suitable for taking over. One of the parties said, well, that's just not possible. You can't do that within a 30-day process, particularly because a solicitor had been chosen as the expert. But the view of the court was that it was in the contract, so the parties had agreed to the process. And again, taking in mind adjudication, where typically disputes are resolved very quickly, there was no reason why a suitable expert couldn't do that within 30 days. And the case a useful reminder about choosing the right expert, because there are a number of solicitors who are perfectly capable of doing that, because they're what you would term construction professionals. They're experienced in the construction process, and equally there would be other people well suited. So it's a process you see quite a bit. You don't hear so much about it because it's a contractual process, and so there's some confidentiality there. And of course, when you do hear about it, it's when a case goes to court and it then becomes public knowledge, and then people are trying to sort of criticize the decision. So there's probably quite a few expert determinations that go on quietly, doing their job, and no one ever hears about them. So that's just one or two experiences I have.
Thank you very much. It sounds as if where the process is controlled and the parties agree to a set of rules and even the identity of the expert in advance, it has much more chance of being successful than if it's more wide open and not predetermined.
Absolutely, because the parties will be agreeing a process at the outset, the beginning of the project, the beginning of the contract, when they're much more likely to be sort of thinking about how do we resolve these things in a sensible way moving forward. So yeah, you may set out a few procedural things. You may have a fallback. If you can't agree an expert, then you go to a particular professional body to get a nomination.
Thank you very much. Okay, Matthew, does that sound familiar to you in your experience? Have you got the same sort of experience, or has it been different?
No, there's yeah, thank you, Rodney. Thank you also to BICAM as well for inviting me to give my views on expert determination and early mutual intervention. So yes, there's definitely some similarities there, and I probably was nodding a bit when Jeremy was talking, because there's definitely some points there that I see as well. It is a very, as Jeremy said, a lot of it you don't see in the market, and I think that is because of the binding nature and the confidentiality basis of expert determination, that we don't see it so regularly going through the courts or going into arbitration. I'm going to give a couple of examples of where I have seen that and the reasons why, but yes, there's a lot of similarities there. So as a firm, I tend to see it, obviously, in my background of construction. I tend to see it where it's very technical disputes, and that can be legally technical. So I have seen it where barristers, arbitrators, essentially people from a legal background have done expert determination, and that's normally because there's a key legal point that needs technical view around and determining that. But also I've seen it also in other areas as well. So IT, I'm very familiar with that it's used quite a lot in outsourcing contracts in IT disputes, but also it's also used a lot within I know that a lot of my colleagues in the forensic accounting team also come across it and do act as expert determiners as well. And that's because of the complexity around sometimes with these shareholder agreements and how they sometimes are also have processes within the contract and the terms that they go for expert determination because of the complexity. So my key takeaway really for expert determination is it's used in those more technical disputes where you want somebody who's technically minded to obviously give that position for the parties, as opposed to maybe a judge or an arbitrator where they may be maybe the skill sets are more broader and they might not necessarily appreciate that technicalities that you're looking for. Because of that, it's obviously a lot quicker than it is of arbitration, litigation, and other forms of ADR, because it's going straight to the issues. The parties, in theory, are agreeing what they want the expert determinator to do. And I think that's sometimes the area where I can see a lot of disagreement sometimes between the parties, is actually when both sides' lawyers are putting together their list of questions and they're putting their own spin to what they want the expert determiner to decide, then that sometimes tends to be an area which takes a little while to resolve. The independence issue is always an interesting one, and impartiality, because I've seen expert determination, not from a barrister, but certainly I've seen one from a surveyor, and I think I've seen one from an engineer, on where there was a bit, essentially their report was almost talking about overriding duties to the court and other sorts of rules that we would find in single joint expert appointments, and also seeing party appointed experts, which is always an interesting one, because in theory of expert determination, it's determinative, it's final, it's binding. It's not necessarily something that you hope it wouldn't go to court. So it's always interesting with that independence point. I think the independence is more around the role of the expert determiner themselves, not so much that they have any obligations necessarily to the court, because their decision ultimately is finally binding. So it's quite interesting when I've seen those reports where they're citing their Part 35 obligations, and you think, I'm not sure that's quite relevant to an expert determination.
On that point, Matthew, sorry to interrupt you, but just on that point, what about challenges? Because we have an expert comes along with a decision. What about challenges and enforcement of that decision? Is that an issue in your experience? I mean, maybe that's a disadvantage of the process.
Yes, yeah. So on the more, I think so, because me and Jeremy talked about this earlier. But the interesting thing is that from an enforcement point of view, you don't see, as we've all said, we don't see many of them in the courts, and you don't see many of them in arbitration. But it's interesting because of the complexity of some of these disputes. So for the example where I've seen arbitrations being used in conjunction with expert determination, the reason why was because there was a legal point around a contract. It was a FIDIC contract it was a FIDIC contract, and it had the standard FIDIC terms and conditions around liquidated damages that anyone that works with FIDIC would be familiar with, and essentially a pre-ascertained loss. And under the law of the country, the law was saying that you couldn't have a pre-ascertained loss. It would have to be actual loss, and you'd have to demonstrate what the actual loss was.
Sounds
So there was,
familiar.
yeah. So exactly. So, and this was in Asia. So it was an interesting one, and the parties were accepting that they could run an arbitration which would go on for many years, and there was many different limbs to this dispute. Obviously, around delay, who caused the delay, why the delay was caused, who was responsible for it, what was the damages of it, etc., etc. So there was obviously a whole range of other issues that then started coming out of this, and essentially the parties would be in dispute around these issues, regardless of whether it was defined to be a pre-ascertained damage or whether it was designed to be an actual calculation of loss. So really, that point, the parties were being quite sensible in saying, well, let's get that dealt with first, because if we get that dealt with, at least we're then essentially bifurcating part of the arbitration, and we're limiting it then down to really the key issues, which is who's actually caused this problem and who's got to pay who. And that was used quite successfully, and there was a very good expert determiner who was an ex-High Court judge, and he did a very good decision, or a very reasoned decision around all of that, and explained the legal parameters of that was used subsequently in the arbitration. So in that scenario, it wasn't so much of an enforcement issue, it was actually more preemptive than that. It was more about the fact that the parties actually accepted that they needed to do that to then move forward with an arbitration later, but obviously ring fence the area of that. And I think that did probably save huge amounts of time. It saved huge amounts of submissions that would have been made, and there would have been experts that would have been required to debate the law, etc. And so really that was an example that I have of where expert determination has been used quite proactively to essentially bifurcate. But the other point around seeing it in the courts, it's very rare that you see an expert determination decision in the courts, and that's because of the binding nature essentially around it. It's an interesting concept, and this comes down to the choice of when you choose an expert determiner, because I'm a surveyor background, and when I'm making a position like I do in adjudications or in DABs and in arbitrations, I make a position as my understanding of the law, or what my basis of the legal position is. Now, of course, in adjudication, that could be wrong, and the courts can obviously, certainly in terms of UK statutory adjudication, can tell me that my position on law is wrong, and they can do something about that decision, and that's part of the process of adjudication. But with expert determination, it's an interesting one, because if it's say a quantum dispute and you're appointed a quantity surveyor, and they get the law wrong, which they possibly could do, then what do you then do about that decision? Because ultimately you're binding to it. So that's probably where the choice of who is appointed to do the expert determination really needs to be considered quite carefully, and also weighing out what the real key issues are, because is it really a quantum dispute, or is it essentially the quantum will just flow from liability, depending on that legal basis, in which case it's probably not a surveyor that you need, it possibly is a lawyer, because the lawyer possibly needs to give that position around the law, and maybe quantum could be dealt with separately. So it's really thinking that through, and I think the parties both come into a consensus on that, which is obviously some of the problem.
And the possibility also, I suppose, of having more than one expert, possibly a panel of experts with a lawyer and a surveyor, and then all rendering a decision. That could overcome that problem.
Yeah, I think the only issue with that is that then it's coming more into arbitration and DABs. So
exactly,
then
by
shoot
another
forward
name
process. Yeah, exactly. Yeah,
time and money and all that's creeping up. Okay, well, thank you very much for your comments, Matthew. If I can now turn to Gananathan and have your comments and perhaps responses to what you've heard from the first two gentlemen so far.
Yes, I think the general introduction to what expert determination is, in terms of how it normally deals with technical aspects of technical nature, and the fact that it is generally binding because it's a contractual requirement, and you don't normally see it being reported in case law because it's private. I think that's all quite correct. But I think from a Malaysian experience, what we are generally more used to is using these experts for determination of specific items, as what Matthew mentioned, in the arbitration itself, or even in an adjudication. So when you look at this expert determination, I'm looking at it from the perspective of dispute avoiding the entire process of arbitration, by that expert determination beforehand. But here lies the problem, and I think something I'd like to give a different angle to. The problem is, I think that as Matthew quite correctly pointed out, you may get a quantity surveyor or an engineer to determine a technical issue, all well and fine. But the moment that descends into a dispute on the evidence or how one reads the contract or the legal requirements that flow from that, then are you really getting the benefit of that expert determination to be able to resolve the issue? So my experience in expert determinations of this sort, it's provided for in the contract, yes. It is most useful when one looks at it in terms of dealing with a highly technical issue, so that the project can carry on after determining that issue, for issues to be then resolved ultimately in arbitration. But when one looks at the way the clauses are worded and drafted, it gives you, generally in my experience, a temporary determination. What do you then do with other aspects of that dispute resolution? So I'm advocating, yes, expert determination is a good thing when one looks at valuation and technical issues, but it is not suitable in situation where the facts are significantly in dispute. There's heavy disputes in evidence, and there are serious legal issues. Now, Rodney, you mentioned that perhaps you can then assemble a panel of people with the engineer, perhaps a legal expert and so on, but does that, the question we then have to ask ourselves, at least from my experience, is does that actually resolve a quick and efficient resolution by way of expert determination? Or do we go through the normal process of taking the matter to dispute, calling an expert, parties get to cross-examine them, and have the arbiter of facts and law finally determine who's right and who's wrong? So I think that's the debate that plays a lot, I think, not just in Malaysia, I suppose even in other jurisdictions. But having said that, if we're able to confine the facts and the evidence within, ring-fence it within and package it nicely for the expert determination, then I would say it would work. Otherwise, I would suggest that we go through the normal route of normal expert witnesses in court or arbitration. And I think another very important aspect when one looks at expert determination, because it's contractual based, is what you would then incorporate into your agreement, into your underlying contract to provide for such expert determination. Does it have a certain sense of finality for the moment? Or is it something that one can then take later? Matthew mentioned bifurcation. I advocate that. So if you're bifurcating your position, you can actually provide for that contractually, determining part of that dispute, but ultimately the rest of it ends up in arbitration, so to speak. You know, when one looks at, say, for example, the valuation of shares, you can get an expert, parties can agree beforehand on the valuation of the shares. But the question then is whether there's been a breach of the underlying contract in respect to the valuation that can then go into a final determination in arbitration. So I mean, that's a little bit that I can add in respect of how one would look at expert determination. It is also important to look at enforcement. I think, Rodney, something you mentioned. Generally, unlike an arbitration award, an expert determination would ultimately result in a breach of contract if it's binding and one party refuses to comply with it. So unlike an arbitration award, which is then subject to other challenges, an expert determination has that slightly different feature when one looks at it. That's what I have to say about expert determination.
Well, thank you very much indeed. What I'm hearing from all of you is that expert determination can be effective, extremely effective, in doing its job of quickly resolving the disputes if it's managed properly, if the disputes which are referred to the expert are appropriate. And interestingly, coming back to Malaysia, in the PAM form of contract, which is the standard building form of contract we have here, there is an expert determination clause, but it allows any dispute between the parties to be referred, which perhaps from what we've discussed this afternoon may not always work. So something to think about. Any other comments before we leave expert determination? Anything you'd like to add? It sounds, from what we've heard, positive, but of course it can also get unstuck. But overall, I would say that it gets a thumbs up if used wisely and appropriately.
Yeah.
Thank you. Okay, so we're just about the halfway mark, and I think it's appropriate because we need a couple of minutes or so to take questions at the end. If we can now move on to early neutral intervention. It's all about achieving informed solutions to lead to dispute resolution much earlier than the common ADR techniques such as mediation. The independent neutral is introduced at an early stage on a without prejudice and confidential basis to encourage a dialogue between the parties that has not been heard before. Talking to and through a neutral can make things happen which otherwise would not. The neutral will work with the parties as follows. I'll just give some examples. The neutral will identify key issues. He'll work out what each party needs to do to inform the other of its position. He'll work out a roadmap, or she, or a shopping list to take the dispute forward. And also, the neutral will identify options of how to contest issues. It sounds like a Mr. or Mrs. Fix-It to me, and I mean that in a positive way, and quite an interesting role as well if you're appointed as an early neutral. So among the benefits, the neutral may help to identify what needs to be on the table to resolve the claim. He may help plan a way forward to a more measured process, and he may facilitate an early exchange of positions towards understanding the dispute. If I can start this time with Matthew as a consultant, as essentially starting a career as a quantity surveyor, now specializing in dispute resolution. Does the description I've just read out, does that align with your understanding of what E&I is all about?
Yeah, I mean, E&I is using a different basis of skill set. So when I look at broadly with disputes, when I'm acting in different capacities, when I'm acting as an arbitrator or an adjudicator, a more determinative role, then essentially I'm weighing submissions. Essentially, I'm obviously using my technical skill set to understand the submissions, but I'm not taking a submission and then I'm going away and looking at it further and effectively creating my own position, because there's a danger of doing that. You're breaching natural justice, you're breaching the party's submissions, and you're breaching your whole role as an arbitrator and adjudicator by doing so, because you're essentially ring-fenced to what the parties are making submissions to, not to advance other sides' cases. And there's obviously lots of case law, particularly in the UK, around adjudicators that historically did that in the early stages of our Adjudication Act. In terms of then expert determination, as we said before, it's more determinative, so it's a determinative role, but you can use obviously expert experience, the same as a party-appointed expert, same as a single joint expert. You're using your role as an expert, not as a witness of fact, to essentially make positions around technical grounds. Now, with early neutral intervention, I broadly put that more in a similar category to what I would put as mediation. So it's more of when I use my mediation skills to do, and possibly also to a certain element to when I'm sitting in a dispute board as well, because you're using a very different skill set. You're not using a determinative skill set, as I said in the previous other two scenarios, whether that's on party submissions or whether that's on technical, and your technical skill set. You're actually using less of that. You're using more of your negotiation and your essentially you're bringing the parties together type skill sets. So you're trying to bring them together. You're trying to understand why they don't agree. You're trying to get them to go along that journey with you. And essentially you're becoming less determinative around positions and essentially allowing them to negotiate themselves, essentially. And I suppose really the really good E&I process will be when you get the parties to a stage where you can almost step out the room and they sit between them and they negotiate and they essentially come to a conclusion themselves of what they're happy to do, and then they continue on. Now, of course, that's the ideal solution and that's what you're aiming for. One of the issues with all of that, and I think it is designed with the process itself, so it's just one of those issues, is that ultimately the parties have to want to do this. So it really needs a lot of buy-in, huge more than arbitration or expert determination, as we were talking about before. The parties have to really want to go through this process, and they really want someone to facilitate that process and help them go through that. And I think that's sometimes the real issue with E&I, which is why it is so rare, is because often within the disputes they escalate through, and then the traditional way of dealing with it is when the dispute becomes too complicated or it becomes too escalated, then you go through a formal process, because it's already become too big for the construction site or for the team and for the employer, etc., for them to be able to make a decision on this, or them to be able to reach a decision. So essentially it needs to come away from them. And at that point, E&I unfortunately doesn't really work, because the escalation's already happened, parties already started to put their submissions together, and they're already in that process of where they're already embarking down a dispute process. So trying to intervene with early neutral intervention at that stage becomes more difficult. Having said all of that, in the UK we have the pre-action protocol, which is used widely in lots of other areas of our law, family law, etc., where mediation is seen as the pre-action that you have to do before you go to court. So even where a dispute's escalating, parties can go to mediation, and they have to attempt to go through mediation first. With E&I, obviously there isn't that process. There's no statutory obligation, as far as I'm aware, in any jurisdiction, of where you have to then do E&I as a process before going forward to another dispute process. So it's really very much relying on the parties introducing it at that point in time.
Thank you very much. So it depends really. I mean, on the one hand, it may be contractual. It may be pre-agreed, predetermined from the outset that there will be a process of early neutral intervention if needed. There are parallels there with the DAB, where getting engagement from the parties, as we were discussing earlier, before we came online, can be a problem, where there's a nice process of dispute resolution through DAB or E&I, and then the parties just don't want to know. They don't want to engage, and much to the frustration of the DAB or an E&I, if he's been appointed and wants to get on and wants to resolve issues, there has to be something put before him or her. That's interesting. It seems to me that it's much more difficult to explain what E&I is, because it can be many things. It's really there to facilitate and to make the process of dispute resolution more efficient, and that can take many shapes and forms. Thank you very much. So let's go back to Jeremy now, because you are both guests to Malaysia this afternoon. So we'll allow you to talk first, and Ghana and I will follow up. So Jeremy, what do you think? What's your experience been like with the E&Is?
That's very generous of you. I note what you said, Rod, about the difficulties in describing exactly what E&I might be. And it may be that subconsciously I had that in mind, because when I thought about what is E&I thought about a process we have called early neutral evaluation, which has been around for almost 40 years in the courts in the UK. It's been around for that long. Evidence is it's not used very much at all, but it's there. It started in the commercial courts. It's now a feature of the construction courts guide. And the idea really is that you get a judge at a very early stage in the process. It may be as part of the pre-action process that Matthew was talking about. And the judge will give a non-binding assessment of the chances of both parties of proceeding. So the judge, you're asking a judge to evaluate the parties' cases such as they are at the early stage. And it can be quite quick, it can be quite short. There may be a short meeting to discuss the case, to enable the evaluator, the judge, to get an idea of what the issues are between the parties. There may be some documents that are given to the judge, and then there may be, I think it's termed a hearing, but I think probably meeting is a fairer approach. And it's not like the judge is cross-examining witnesses. The parties make submissions, and the judge or the evaluator will then ask questions of the parties. And then where that's already slightly different from mediation because everyone is together. And then the second way where it's different from mediation is that the judge is going to give their view. It's obviously a provisional view because of the early stage, and it's a non-binding view of the strength of the evidence available to the parties. Effectively, he's doing what many people find it frustrating that mediators don't do, and that is give an opinion of the respective merits of the parties' cases. Now, that can be a good thing or a bad thing depending on who you are. Because I've sat in mediations with clients who are deeply frustrated that the mediator won't say, well, I think you've got a good case there, but that's poor. And they don't do that because that's their job not to do that. That's the mediation process. And equally, I've been in mediations where the client doesn't want to know. They want to be brought together. So this potential strength of this early neutral valuation, early process actually is, it gives, you get an idea of what, let's face it, an experienced judge view is of your case. The obvious disadvantage is that it's an early stage. Cases might not be fully formed, but most judges have been around a while, and they will have a fair view. So in many respects, it's sort of perhaps surprising it's not used that much, and it might be simply because there are so many different forms of ADR that are available to the parties. I mean, I was saying earlier, where in the UK it's taken off is in the family courts when there comes to matters of financial evaluation. I mean, partly because it's a technical thing, and partly because it's a means of sort of keeping the process private. But it's something that's actually potentially useful if you want to know what an independent third party's views are of the case. So in which case, as I said, it's quite similar to dispute boards and the concept of an informal or advisory opinion. So it's not used very much, but perhaps it should be used more.
And if it is used and the parties act on it, there may be resolution, which is what is needed.
Which is the whole idea. And you're at
Correct.
a very early stage in the process. You haven't got, I mean, another advantage is you haven't got entrenched positions. You may well not have a pleaded case already. So there's still some flexibility, and there's more scope for the parties to be able to come to an agreement. And so, if you've got a really poor case, better to know early.
That's right. I mean, I think if we look at construction contracts which have multi-tier dispute resolution processes, the focus is nevertheless always on ending up in arbitration. And many advisors, many representatives will probably think, well, this is likely to go to arbitration, and we'll pay lip service, or we'll try mediation, but it's unlikely. And they're always got their eye on arbitration. And that's, I think, in some ways unfortunate, because if the parties had a culture of really doing their very best at the early stages, a lot more could be done. And nobody needs to worry about being out of a job, because there's always something different to do. And we'll always be busy settling disputes earlier than being in a longer process, right? There's always work to be done. So we'll never run out of work, if that is indeed a concern.
I mean, I think that's absolutely right. And it's all about culture. We're talking about dispute avoidance. I mean, one of the things I do is involved with a group called Conflict Avoidance Coalition. And that's all about avoiding disputes at a much earlier stage. But part of the battle is changing the culture.
I mean, if I just say, as an example, since we're guests of BICAM this afternoon, the culture in Sabah and Sarawak, in my experience, is to do a lot more in the early stages to negotiate and resolve disputes and avoid at all costs going the formal arbitration or court matter. I don't know if that's Gananathan's experience or not. And I want to ask you, culture in Malaysia in early dispute resolution, what do you think? Is there any signs of that?
Well, I must say, E&I is totally a new kid in the block, I think, as far as my experience goes. But I understand that it falls very nicely as a subset of mediation. Now, the experience I had in doing mediations in the early days, I haven't done one for a while in the courts. And, it used to be the judge would call us to do the mediation, was the fact that the judge would try and look at the best and worst case scenarios of both parties, facilitator or communicator to try and bring them together. But what was lacking in those times was the fact that you didn't have an E&I. The way I see E&I is that the difference between the mediator, if they work together, a mediator and a person who comes in as a neutral, is that the mediator does not decide on the merits. He facilitates the communication, but corresponding with that, we'll have what we have is we would have is this neutral who would look at it, assess the case, and basically make a preliminary evaluation of the merits of the case. And I think that's a very useful tool, which I think should be used extensively, especially in our courts, when one is looking at mediation, with the E&I being a subset of mediation. The downside to it, Martin, I can come and answer your question now, is of course, the Malaysian culture is of course always there to try and resolve matters. But the flavor that comes out of it is, it's not binding. Generally, you're going to find that mediation and the subset being E&I is not binding. So the way in which the neutral can come in, assess, basically look at the merits of the case, it gives parties, before they saddle up and go to court and start becoming contentious with each other, an early opportunity. So I agree with the fact that this should be carried out at the earlier stages. It is not going to work later in the process. And whilst the equal, the neutral looks at this position where he can do an early intervention and come up with an early assessment of the merits, I think what it facilitates is that there is at least a basis for parties to go away and say, let's settle this matter on an informed basis. That's the benefit of having a neutral come in and look at it, because otherwise mediation by itself doesn't take you very far. And whilst the neutral does that, we are looking at the mediator himself dismantling the distrust between the parties, dismantling the posturing the parties would generally do once they go to court. And if this is done at an early stage, I think, in my view, it'll be a very useful process. The only downside to that is, I think you would need, at least in the court system, if one judge was to do the mediation, and a brother or sister judge was then to do the neutral intervention, looking at the merits, one must take into account their very busy schedules as judges. I mean, they may not have the timetable. So I would advocate actually going outside the court system, appointing, say, a senior counsel to look as a neutral as to the merits and come up with an early assessment. The only caution I would have is if it's going to be an elaborate process, then again, it's not going to work. So, if that assessment is given with a very clear set of facts put to the neutral, then I think we would come up with a suitable solution. And I think this is something we should adopt in Malaysia in a much wider way than what we're doing now. I would say that's my view.
Thank you very much. So if we look at mediation for a moment, then the problem there may be that it's a whole process the parties sign up to, and it runs its course, and the mediator has a job. We've heard views about lazy mediators, hardworking mediators, mediators doing too much, doing too little, but the parties have signed up to it. So they go through that process. Whereas with the early neutral intervention, it could be much more selective. And it doesn't have to be a whole process. It can be, let's take one aspect of the dispute. And that in itself, if it bears fruit, can help the rest of the dispute. So it seems to me that there are tools here that could be used, which would certainly assist in the road to settlement. And the road to settlement is often bound by a process which is heavy and cumbersome and costly and time consuming, which, you know, we know is arbitration in construction matters, and the courts are quicker nowadays, but the whole process is tedious and relationship destroying, which is also, and also when there are serial contracts and companies and parties have relationships over a long time, there may well be more opportunity to use these techniques early on, just to unlock and to move the dispute forward instead of becoming entrenched in positions in the process of how we normally, unfortunately, resolve disputes. Gentlemen, any other comments before we're getting on? We've got about 10 minutes left, and we'll probably need to look at some questions in a moment, but anything else you'd like to offer? I mean, I have got a lot of hope from this conversation. I was pretty positive about this before, but overwhelmingly good news about these processes from what you said this afternoon. Would you all agree with that?
I mean, one
Yes.
point I was going to make, Rodney, was just also using hybrids between between different processes. I mean, we would talk about different tools for essentially different disputes. But I mean, one of the great examples of that in Asia is China with the use of MedArb. And I appreciate we're not talking about MedArb, but you know, there's various different forms of MedArb. You can have ARB, Med, and MedArb. So you can mediate, arbitrate at different points essentially. And so really with these two processes, if for argument's sake you are signed up to an IChemE formal contract, which typically has expert determination as a process, which has been very successful in terms of the IChemE, particularly the White Book historically, then you could, as parties, agree that before you go down that process of using early intervention process or mediation or something similar, for the reasons that we were talking about earlier about keeping relationships, keeping the project on track, etc. And I suppose really using these hybrids sometimes does, and multi-tiered dispute processes are designed to really escalate it out to the right level. So it's not a case sometimes, and I appreciate we sort of debate whether it's better to arbitrate, whether it's better to mediate, whether it's better to do this, but I mean the bottom line of it all is that it's going to be different for different disputes, and essentially don't overlook the fact of using a hybrid or multi-tiered system, because they're there and they're there for the effectiveness of that process. So you start small and build up from there. Sometimes that can come out with the favourable outcomes that the parties are looking for.
One thing that you just touched on, and I'd like to put it to all of you, is, of course, there is a big difference between disputes arising during the course, and we all do a lot of work in construction, in the course of the project, and then after completion. It's an entirely different dynamic. And I think, again, to me, I would say that the use of these techniques early on to nip the dispute in the bud. We've got FIDIC contracts with the engineer's decision and so on, and determinations, which can not always be helpful as a process. But into introducing these types of process in the project, I think would be even more productive than possibly using them later on when things are escalating already after the project is completed and we don't have the right people around to bring in to help move the thing along. Any thoughts on that?
I mean, I think that's absolutely right. And you sort of talk about hope, but I think that there is just this general trend globally for parties looking to see how they can avoid disputes escalating. And the key thing, as you said, is real-time dispute avoidance, real-time dispute resolution, trying to deal with things as they happen before they happen, or rather than storing everything up. And bringing in an expert or an early neutral evaluator, certainly if you haven't got other tools already set out in your contract, would be a good thing, because try and sort things out whilst you're going along on the project. That's a huge advantage to everyone, I would have thought.
Sure, thank you.
Yeah, I would agree with that, Martin. I think make a very clear point there as far as construction infrastructure projects are concerned, to have that early resolution with the one objective in mind, ensuring that at least the project carries on with the benefit of that early determination, just like how a dispute adjudication board would deal with these matters as they come along. These processes would certainly help. But as I would just say again, I think it really depends on how the contract is worded as well, and what you provide for as a mechanism to resolve it.
Yeah, I mean, something that's just come to mind is, I'm sure we've all been in arbitrations which deal with termination cases, and the records are just so inadequate. So to have a neutral to come in upon termination and set out what needs to be done to move forward with the inevitable dispute and disagreements which will arise, but so much more can be done at the right time to save either party or both parties. Yeah, thank you. Okay, Matthew, anything to just add on there, or are you good?
No, that's fine. Thank you.
Okay, thanks. Now let's just see if I can get the chat box open and see what we've got. Okay, no questions. Only one gentleman reminds the participants are to have their. Okay, no questions. As predicted, everybody's gone a bit shy. Have we got any questions? Would anybody like to switch on their cameras or their microphones and ask this delightful panel, this learned panel, a question or two? Not me, the others I'm talking about. Any questions? Sharifa, you might have to do your magic here and get your wand out. Have you got a question?
Yeah, actually I do.
Oh, good. Go ahead.
Just 1 second. There's a bit of an echo.
No, you're good.
Okay, is that better? Can everyone hear me?
Loud and clear.
Okay. Jeremy mentioned early EVE.
E&I.
E&E.
E&E, yes, E&E done in courts, which is similar to mediation done by the judges, except that the judges give their opinion on the matter. So if that is already a mechanism that has existed in the courts, then how does the judge decide whether or not to go for mediation or E&E?
It's two separate processes. I probably wasn't clear enough. You have the court process and the various court submissions. E&E is a process which is separate from the court case and the court submissions. It's there as an option which is offered by the courts. So if it needs the parties to agree, and what they would do, they would approach the particular court, say the construction court, and say they've got a case where they'd like to get an early neutral evaluation, E&E, from a judge, and then they would go through and they would arrange that, and that would be completely separate from the court process. The judge who does the E&E cannot be the judge who hears the case, because that would just be wrong for a number of reasons, as you were suggesting. So it's two separate processes.
Okay. Oh, well, I have a follow-up question if no one is asking. So, is the option to conduct mediation there for the judges, or can they just go straight for E&E?
No, a judge could not act as a mediator. As Matthew suggested when he talked about the pre-auction protocol, mediation is there as one of the options for the parties during the court process. There's been a recent case from our Court of Appeal where the judges who traditionally will encourage mediation can now say that parties should mediate, but the judge always is in their decision-making role. They can't be the person who acts as a mediator, I suppose, because the processes are different. The mediator will meet with the parties alone, so they might meet with me and then they'd go away, and then they would meet with Rod separately, and we might tell them things that we don't want. I might tell the judge something that Rod doesn't want. I don't want Rod to know, but it's important for the mediator to know, to be able to try and bring us together. Whereas the court, it's all about open transparency. Everybody hears everything that I have to say in part of my case. So a judge cannot be a mediator of a case where they are acting as the judge. It's two separate processes.
Okay, I've got a question from Kevin Prakash. While these dispute avoidance resolution processes are certainly helpful, they are costly. They seem to be tools only the large employers, contractors can afford to use. How do we democratize these processes from a cost perspective? That's a good point. Everything's got a cost. Any ideas? Any proposals?
I think what I was going to, just in terms of response to that, so expert determination, there are rules out there where it can be an extremely short process. So, for example, the Academy of Experts have a process which parties, I can't remember quite the times, but I've got a feeling it's 2 weeks and then 2 weeks. So essentially the process is done very quick. The expert determinator does have a little bit more, I think, ability to be able to extend their own time frame for making their own decision, but the idea of the process is it is extremely short. And so if that process for expert determination is, say, for argument's sake, is happening within 6 weeks, that's quite a quick process. And the idea is that really the parties aren't really putting lengthy submissions to the expert determiner. They're putting essentially questions to the expert determiner. So there's not huge amounts of legal costs because you're not paying for lots of lawyers and lots of lots of submissions, etc., barristers, whatever. You may still obviously likely will need counsel to obviously draft those questions, but the idea is that it's meant to be a bit quicker. The other example of that also is statutory adjudication, and the way that we've seen the UK, Australia, Canada, Ontario and others, where they've gone down the adjudication route. And the reason, again, for that is all to do with cost. I mean, adjudication in the UK has become more generally, I'm pretty sure this is for debate, but it's generally seen as a pretty cost-effective solution. So if it is a small contractor that, say, for argument's sake, hasn't been released their retention and it's £10,000, the whole idea of adjudication is that they can afford to get an adjudicator to give them a decision that then is enforceable should the other side not release their retention, for argument's sake, in a construction case. Expert determination could be used in exactly the same way as well, and often is. So for something like, I've seen it quite often used for certification reasons. So arguments about whether practical completion was actually achieved or not is a famous one that I've seen expert determination used quite regularly, because it deals with the issue, it deals with it quite quickly, and it frees cash up quite quickly. So I would say that these options are definitely far more cost effective than arbitration, unless they get into the real technical areas of where they then end up becoming a mini arbitration, which of course then becomes more costly. But if they're being dealt with for small supply chain issues, in theory, they're designed to be very cost effective by nature.
And it's all relative, of course, because the idea of having these processes come in is to avoid that higher cost of arbitration, which is the only other route to take, right? But point taken from Kevin that these may still have a cost which may be prohibitive to some parties, which is a problem. Okay, well, Sharifa, we've come across the timeline. So I'd just like to say thank you very much to the panel for your contributions and your time. And also thank you, BicTok, for inviting all of us to take part this afternoon. I've found it very interesting discussion. Thank you.
Thank you so much to our panelists and to our speaker. Thank you, gentlemen, for joining us. It's a shame we could have gotten more participants because I definitely paid attention from start to finish. I have actually more questions, but I'll approach you separately. Anyways, thank you so much, everyone. Enjoy your evening and see you next time for our next Big Talk.
Thank you very much.
Thank you.
Thank you.